morning. It's Kristen with My Pink Lawyer, continuing our discussion about Florida living trusts today. So a common question is, can a trust be used to repay a person's creditors after they die? So typically, when a Florida probate is opened, notice needs to be given to the Florida creditors, and they are given an opportunity to file a claim in the estate. Well, if all of the assets were owned by a living trust when a person dies and no probate is needed, what's the process of repaying a person's creditors? Well, one of the requirements of a successor trustee after the person dies is to file with the court what is called a notice of trust. And this puts any creditors on notice that the person who died did have a trust, and there may or may not be assets available in which to go after from the trust. Normally, the statute of limitations for unsecured creditors getting repaid from a person's estate is 2 years from the date of death. This window can be shortened by publishing a notice in the paper, the local news publication of the person's death, and it's called a notice to creditors, and it shortens the window from 2 years to 3 months from the date of first publication of the notice. So that's another option if a trustee is concerned about creditors coming out of the woodwork before making distributions, is they can always go ahead and file a notice to creditors or publish it in the paper to shorten that statute of limitations. But they definitely have to file with the court a notice of trust. Creditors then can go after assets of the trust that would not otherwise be exempt in order to repay themselves. But it is a few more hoops for them to jump through since there is no probate opened in the first place. For more information, check out our website, mypinklawyer.com, and you guys make it a happy 4th.